Yes. I hope my screen is visible to you guys. Someone has to confirm.
Yes, sir, visible.
So we had already discussed uh, what is it that you mean by a transfer? What are the kinds of transfer? What is it that you mean by a property, which is not defined in the code itself, but then we went ahead and defined it. What are the types of properties? We discussed what is a movable property, what is an immovable property. Uh, Today we'll as let me just remind you one thing, that how do you distinguish between a movable and an immovable property? The real thing that you have to notice here is the intention behind it. If the people who possess that property, or people who have that property, want to see, basically if it is a land, it is immovable. Obviously there is no reason behind it. If you can move a property, that is movable. That is, there is no second thought about it. I'm talking about the things that are lying in between, that are not movable per se, but not immovable per se, but you have to compute it, you have to take it as one, because you can't take it as both, because the registration for them are different, the way you deal with them are different. That's why you have to consider it as one. For that, you have to make sure that you treat it as either as movable or as immovable. In that case, you have to see the real intention behind uh, how you are treating it. So if I intend that this grass or this tree that I have planted, it is for a permanent period, I want to enjoy the fruits that are coming from the tree, then that will be an immovable property. But if it is meant for a timber purpose, if I want to use it for the wood that is coming out of it, then I want to obviously sever it. In that case, that becomes a movable property. So now coming to the silent features, I probably missed out these silent features, the important features of the Transfer of Property Act. You have to, because these are very important for the prelims or the multiple choice questions that are coming. So you have to know that it was enacted on 17th February 1882, came into force on 1st July 1992. Sorry, that is 1992. I have written it. Must be 1882 only. Yes, 1882 only. I have written 1992. It's my date of birth only. I have written like that. So anyway, transfer of property will define it. Will know it when we go to section 5, which is obviously means by transfer between one living person to another, because we had discussed that it deals with not the testamentary form of, not the intestate succession, but the testamentary form of succession. So basically, not the, if you uh, uh, we had distinguished the intestate succession and testamentary succession, and according to that only we had discussed that whether it is uh, a transfer of property that is being that is governing the rules thereof, or the sales of goods, or the Hindu Succession Act or the Indian Succession Act, as the case may be, they are dealing with it. Anyway, we just have to know that if we read section 4 of the Transfer of Property Act, it is very evident that it is nothing but a continuation of the Indian Contract Act. Indian Contract Act was framed in 1872. Then somehow the legislature thought that they have missed out on certain points. So in 1882, they made sure that the Transfer of Property Act contained all the provisions which are missing out on the Indian Contract Act. Indian Contract Act was saying that how the contract how the contract will be formed, how the transaction will be made, but how the process of that transaction will be made, that is given in Transfer of Property Act. The section 4 also says that it supplements the Indian Registration Act. But we also have to know that it mainly deals with immovable property. And when I say that it mainly deals with immovable property, that goes to show that it also deals with movable properties. In some chapter, there are parts of the chapter which actually deal with movable property, like section 5 to Section 37, they apply to both movable and immovable. But we have to also know that sales of goods is the Goods Act is the chapter which is dealing with the movable properties per se only. Section 38 to 53A only immovable part, and the gift chapter, that is of the Transfer of Property Act, that is dealing with both movable and immovable property. We also have to know that the Muslim law, it overrides the Transfer of Property Act in certain cases. The second chapter of the Transfer of Property Act, that is when it says something and the Muslim law or their contractual law says otherwise, then that law will override the second chapter of Transfer of Property Act. These are basically silent features, just to give you an overall idea. Anyway, our main point of discussion would be the interpretation clause that has been enumerated in Section 3 of the Transfer of Property Act. But let me just carry ahead with the silent features. Again, you have to just notice that it is an act which is prospective in nature. That means that an act that is applied when it is coming into force, and only after that the laws or the transactions that are happening, only those are governed by transfer of property. So basically, you have to know that all laws are prospective unless it has been specifically mentioned. You have to know this, that never a law will be applied retrospectively without notifying, and that it will be applied to you retrospectively. And when I say prospective and retrospective, ଆପଣଙ୍କୁ ଆମକୁ ଏଇଟା ବୁଝିବାକୁ ପଡିବ ଯେ prospective କ'ଣ and retrospective କ'ଣ. Prospective is that which is applied to you after the act came into force. Act ଟା ହାଜିଠୁ ଆସିଲା, ଏବେ କୁହାହେଲା କି ଏବେଠୁ ତମ ଉପରେ act ଟା ଲାଗିଲା. But if it is a retrospective act, then that will be applied to you before some time. So an act today came and it is saying that even though the transaction happened in way back in 2016, it is a this act is being applied to that. That is a retrospective application of the act. But if it is, the act will be applied to all the transaction or the happenings that are happening after the act came into force, then it is a prospective act, or the act is coming into force being prospective in nature. So you have to know that before transfer of property, only the law of equity and justice and good conscience, that was being applied, because there was no law dealing with the transfer. They're dealing with how the transfer between one living person to another will take place. Only there was justice, equity, and good conscience that was prevailing, and the judges or the British lords, as you may call them, they were only concerned with the justice, equity, and good conscience, and accordingly they were dealing with the cases that were coming. Now coming to the section 3, that is the main topic of our discussion today. We had discussed certain elements of section 3, that is movable property, and everything. Now we'll discuss the rest of it. One thing that has been defined in section 3 is an instrument. It just says one thing, that when I say that it is an instrument, that means it's a non-testamentary instrument. According to this act, it must be a non-testamentary instrument. Why? Because we are not concerned with testamentary instruments. Because if the TPO Act was dealing with testamentary instruments, then only the instrument would have meant that it is a testamentary or intestate instrument. This is a non-testamentary instrument only that we are concerned with, and that's why when I say that it's an instrument, it only deals with non-testamentary instrument. Then it excludes that the intestate document, all the documents or instruments that are dealing with intestate ones, that means they are being governed by Hindu laws, Mohammedan laws, or other personal laws. Then in that case, they will be not included with the concept of instrument. Then coming to the definition of attested, it is a very important definition. Very often it is asked, maybe a very complicated section, because if you look at it, it looks very huge, but then you have to just remember a few ingredients and you can probably write your own version of the definition, and that should be equally effective. Attested means that when I say that it is an attested document, that means it has been attested by two or more witnesses. Two or more persons, if only attest, then only it is called an attested document. So attested means that it is done by two or more witnesses. Now comes the tricky part. What are the ingredients that are to be satisfied when you say that it has been attested by two or more witnesses? First ingredient is that it must be the fact that the two or more witnesses must have seen the executant sign. That means whoever is making the document, while after he had made the document, he must have put his signature, and uh, that thing of that fact of he putting the signature must have been witnessed by the witness. A witness, ଦି ଜଣ witness କରିଥିବେ, ଦି ଜଣ witness ଭିତରୁ ଦି ଜଣ ଯାକ ଦେଖିଥିବେ that executant ତାର signature put. That is one ingredient. If that is not happening, that the executant could not put his signature, that can be times that executant could not put his signature or affix his mark, as the case may be. Like in the case of Parda Nation ladies, they can't come out of the veil. So there can be cases where they can't sign themselves, or they are unable to put their signature because they do not have hand. So they ask someone, other person, to sign it. If they have seen that person affix his mark or sign, then also that is deemed that yes, they have seen it. So the ingredients, when I say these three, one of such ingredient must be satisfied. First three ingredients, one of such ingredient must be satisfied. First is that they must have either seen the executant sign or affix the mark. Second is they must have seen some other person sign as per the direction of the executant. That means the person who is making it, he directed that you sign. Now the witness was present when he directed and he put his signature. In that case, it will be treated as if he has seen it. Or the third case, if the example that I gave, that the Pradhan Nation lady, he couldn't come out of her veil, and he couldn't sign in front of you, but he gave a personal acknowledgement. But she gave a personal acknowledgement that yes, this is in fact my signature. She gave a personal acknowledgement to the witness that yes, in fact it is my signature. Then also it will be deemed as if the ingredient of the attestation has been met. So as I told you, out of three, all three are not to be satisfied. If one of the ingredient is satisfied, then also it will be deemed as if the ingredient that is required, that has been met. Now coming to the fourth ingredient, yes, that is a compulsory one. So one of the first three, that is a compulsory. So 1/2/3, that is one ingredient. Now the second ingredient is that each of whom means that the witnesses, the two or more witnesses, they must have put their signature in presence of the executant. The executant was present and the witnesses put their signature in front presence of the executant. That is a non-negotiable part. But then when I say that they must be present, they must not be present at the same time. You're getting it? So they must have been present to sign in front of the executant, but they can come one after another. I'll give you an example that an executant A made a certain document. Now B and C are witnesses to this document and they are attesting it. Then in that case, they have to be present and sign before A. But that doesn't mean that they have to be present together. B had some work, he couldn't come today. So C only came and put his signature. The next day B came and then he put his signature. That will be sufficient that yes, the ingredient has been made, because they were present and they put their signature, but it was not necessary for them to be present at the same time. Another ingredient is that there is no particular form which is necessary for a valid attestation. That means that it is not written that you have to you have to write the attestation or you have to do the attestation. That is not necessary. You can do in any way, and that is fine. Now coming to another simple definition, that is registered. Registered means that registered in applicable territory, that means in the territory to which this act extends. And the registered also means that it has been registered under the law in force relating to the registration of documents. It is not a complicated definition, and it is not also frequently asked, so let's just skip it and move to actionable claim. Yes, this is a very, very important definition. Actionable claim, simply put, that a claim against which you can take an action. But then when I say that a claim for which you can take an action, that claim must not be a claim for which you have already taken some security. So for a claim, ଗୋଟେ ଧାର ଗୋଟେ ଯୋଉ ମାନେ ସପୋଜ ଏ ଏକ୍ସାମ୍ପଲ ଗୋଟେ ପୁରା ବେସିକ ଏକ୍ସାମ୍ପଲ ଟେ, ଏ ବି କୁ କିଛି ପଇସା ଦେଲା, ବଟ୍ ସେ ତାଠୁ କିଛି ବି ସିକ୍ୟୁରିଟି ନେଇନି। ଯଦି ତାଠୁ ମୁଁ ଘଣ୍ଟାଟା ରଖି କହିଲି ମୁଁ ତ ଘଣ୍ଟାଟା ଦେ, ରୋଲେକ୍ସ ର ଘଣ୍ଟାଟା ରଖିଛୁ, ରୋଲେକ୍ସ ଘଣ୍ଟାଟା ଦେ 1,00,000 ଟଙ୍କା ମୁଁ ତତେ ଦଉଛି, ଯେବେ ତୁ 1,00,000 ଟଙ୍କା ଫେରେଇବୁ ମୁଁ ତତେ ରୋଲେକ୍ସ ର ଘଣ୍ଟାଟା ଦେବି, ହାଇପୋଥିକେସନ ଭଳିଆ ଦେଲା। In that case, ଯଦି that happens, that is not an actionable claim, because the definition says, if you read the definition, I have written unsecured money debt. To be very simple, it is nothing but an unsecured money debt. A debt which is not secured, that is an actionable claim. The definition, probably they have tried to complicate it again, and they have written that it's a claim to any debt other than a debt secured by mortgage of immovable property, or by hypothecation, or pledge of movable property. So basically a debt which is secured by a mortgage, or a hypothecation, or pledge of movable property, if that happens, then that is not an actionable claim. The reason being simple, that you of course have certain security, and basically when you give a certain money, you always make sure that you have a security of a higher amount. ମୁଁ ଆଜି 1,00,000 ଟଙ୍କା କାହାକୁ ଦେଲା ମାନେ ମୁଁ ଭାବିବି ଯେ ମୁଁ ତାକୁ କେବେ ଆଟଲିଷ୍ଟ 2 ଲକ୍ଷ ଟଙ୍କାର ଗୋଟେ ସିକ୍ୟୁରିଟି ରଖିଥିବି, ଆଟଲିଷ୍ଟ ସେକେଣ୍ଡ ହ୍ୟାଣ୍ଡରେ ବିକିଲେ ବି 1,00,000 ଟଙ୍କା ମିଳିବ। That I'll make sure. ମୋତେ ଗୋଟେ ଲ୍ୟାଣ୍ଡ ଏଗେନ୍ଷ୍ଟ ଲୋନ୍ ଦଉଛି, ବ୍ୟାଙ୍କକୁ ଆପଣ ଯିବେ, you take a land against loan, ସେମାନେ ସବୁବେଳେ କହିବେ ଆପଣଙ୍କ ଲ୍ୟାଣ୍ଡର ଭ୍ୟାଲ୍ୟୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଭ୍ୟାଲ୍ୟୁ ହିସାବରେ ଲଗେଇବେ, ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଭ୍ୟାଲ୍ୟୁ ଏଗେନ୍ଷ୍ଟରେ ପୁଣି ତାକୁ ବି 70-80% ଭଳିଆ ଦେବେ, so that they can get their money. So in that case it is not required. ଯଦି ଗୋଟେ security ଅଛି when they are giving a debt, then that is not required at all. ଯଦି security ନାହିଁ ସିନା ସେତେବେଳେ problem ହବ। So for that only this thing is required, that how will you deal with a situation when you have actually given a debt and you have not taken any security from the person to whom you have given the debt. So if it is an unsecured money debt, then it is an actionable claim. And second part of the definition says that it's a claim to any beneficial interest in a movable property not in the possession of the claimant. And when I say not in the possession of the claimant, I mean to say that it is not in the actual or constructive possession. Now we'll know what is actual and what is constructive possession. All of the literal meaning would be that if I have the car and I am possessing it, I'm driving it every day to the office, that is actual possession. But if I have given my car to someone else, or that I went to Goa and I kept the car in the airport's parking, for that, though the car is not in my actual possession, it will be deemed that it is in my possession. It is a constructive possession that I have. So in that case, if that will be also construed that it is in my possession. So this says that if it is a claim to a beneficial interest in a movable property, so basically I must have an interest which is beneficial, and it must be over a movable property only. Then in that case, example, very very raw example would be insurance. Insurance ଆପଣ ନେଇଛନ୍ତି, ଆଜି ଗୋଟେ term insurance ନେଇଛନ୍ତି, term insurance, suppose the person who has taken the term insurance died. In that case ସିଏ ତମକୁ ଆପଣଙ୍କୁ ଖାଲି ଗୋଟେ bond ଦେଇ ଦେଇଛି, ପଇସା ତ ଦେଇନି ନା, 1,00,00,000 ଟଙ୍କାର ଯୋଉଟା insurance ନେଇଛନ୍ତି 1,00,00,000 ଟଙ୍କା ତ ଆପଣଙ୍କୁ ଦେଇନି, so it is not in your possession. It is just a security, it is just bond ପାଇଁ ଗୋଟେ ଦେଇଛନ୍ତି, so that ଆପଣ ଜାଣିବେ କି ହଁ ଏତିକି ଟଙ୍କାର ଗୋଟେ ଅଛି। but ସେଥିରେ କିଛି actually ସେଟା ଆପଣଙ୍କ possession ରେ ନାହିଁ, then in that case it will be deemed to be an actionable claim. You can take an action if they do not give you the money. Rent ଆପଣ ଭଡାରେ ଦେଇଛନ୍ତି, ସେ ପଇସା ଦେଇନି, I have, that will be an actionable claim. ଭଡାରେ ମାନେ ଜିନିଷ ନାହିଁ, ମୁଭେବୁଲ ଏଥିରେ ପ୍ରପର୍ଟି ଯାଇଛି, ଆପଣ କେବେ କହିପାରିବେନି ଯେ ଗୋଟେ ଜମିକୁ ଭଡା ଦେଇଥିଲି ସେଇଥିରୁ ମତେ ଦିଅ, ବଟ୍ ମୁଁ କହୁଛି ଗୋଟେ କିଛି ଜିନିଷ କାର ଭଡାରେ ଦେଲି, ତାର ରେଣ୍ଟ ଟା ଦବାର ଥିଲା ବଟ୍ ସେ ଦେଇନି, that will be an actionable claim. Interesting example would be that suppose ମୋ ଗାଈ ଯାଇକି ଏବେ ଆଉ କା ଫାର୍ମ ରେ ପଶିଲା and ତାର କିଛି ଖାଇଦେଲା ପରେ obviously ସେ କଣ କଲା ନା ସେ ଗାଈଟାକୁ ରଖିଦେଲା, ଏଇଟା ରଖିଦେଲା ନା ଛାଡିବିନି ଯେପର୍ଯ୍ୟନ୍ତ ଯାହା ମୋର ଲସ୍ ହେଇଛି, what ever loss has accrued to me, that has to be substantiated by the owner, if not I will not release the cow. So that cow which is a movable property and it is not in the possession of mine because he has kept it, that will also be an actionable claim. Of course, you have to know that this must be a claim which is recognized as a ground for relief by the civil courts. If the civil courts do not recognize it as a ground for relief, then it cannot be an actionable claim. And you have to also know that it can be either existing, it can be accruing, it can be conditional also, that on the happening of this I'll get this, or it is existing that yes I'm about to get it, or accruing that on the month of May or in the month of June I'll get it, and in that case also it is accruing, but it is still an actionable claim. The examples are rent for a movable property that I have given, share in a partnership, earnest money. So for a contract I have given some earnest money. What is an earnest money? That ତାକୁ ମୁଁ କହିଛି ଯେ ଘରଟା ମୁଁ ବିକିବି 60 ଲକ୍ଷ ଟଙ୍କାରେ, ସିଏ ମତେ କଣ କରିଛି ନା ଗୋଟେ ସର୍ଟେନ ଆମାଉଣ୍ଟ ଦେଇଛି, ଲକ୍ଷେ 2 ଲକ୍ଷ ଟଙ୍କା ଆଡଭାନ୍ସ ଦେଲା, ସେ ଯୋଉ 2 ଲକ୍ଷ ଟଙ୍କା ଦେଇଛ ତା ପାଇଁ ସେ ତ କିଛି ସିକ୍ୟୁରିଟି ନେଇନି, ସେ କଣ ଗୋଟେ ଆଡଭାନ୍ସ କରିଦେଇଛି, being in good faith, କିଛି ସିକ୍ୟୁରିଟି ରଖିନି, in that case that 2 lakhs which is lying with me, that is an actionable claim of the person who is claiming. And as I told you, it is a debt generally which is not secured. Again, you have to know that claim for damages and mean profits, they are not actionable claim. What is a claim for damages? Damages as in I have made a contract with B and to purchase certain goods, but then I did not fulfill the contract, I did not purchase it. He can claim a damages from me that you did not, and my goods were perishable in nature, and that's why they perish in the process. If that is the thing, they can claim damages as per the Indian Contract Act. They can't treat it as an actionable claim here. Mean profits, what is mean profits? That they are not actionable claim. The cow example that I gave you, if you consider that ମୋ ଗାଈ ଗଲା ତାଙ୍କ ଫାର୍ମରେ ପଶିଲା, ଜିନିଷ ଖାଇଦେଲା, ସେ ଗାଈ ରଖିଦେଲା ପରେ ସେ ଗାଈ 2 ଦିନ କ୍ଷୀର ଦେଇଛି, I can't treat those milk as actionable. Mean profit, in the meantime it has accrued. You getting it? Suppose mean profit means in the interim the profits that have been accrued, they will not be actionable. Now coming to the most important definition of section 3, that is notice. And notice, how it is important and why it is important, you have to know that notice is very important because law will only punish you or reward you, as the case may be, only if you have the notice of that thing, notice of a certain thing. And notice means nothing but to be aware of a fact, to be aware of ଗୋଟେ ଜିନିଷ ହେଇଛି ବୋଲି ମୁଁ ଜାଣିଛି, ଗୋଟେ ଜିନିଷ ନ ହେଇଛି କି ହେଇଛି ବୋଲି ମୁଁ ତା ବିଷୟରେ ଜାଣିଛି, that means I have a notice over that fact. And how it is important, I told you that the courts or law will only take action against certain things if that person has a notice of that fact. So basically what is court ଆପଣଙ୍କୁ summon କରିଛି, court has summoned you, court ଗୋଟେ summon ପଠେଇଛି, ଆପଣ summon ଟା ଯାଇକି ଆପଣଙ୍କ ଘର ପାଖରେ ସିଏ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟରେ ଗଲା, ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟରେ ଯାଇକି ବେଲ୍ ମାରୁଛି, ଆପଣ ଦେଖିଲେ ଉପରେ ଦେଖିଦେଲେ ଯେ ଲେଖା ହେଇଛି ସିଭିଲ କୋଡ୍ କଟକରୁ ଆସିଲା, you thought ki it's a court document, I know ki ମୁଁ ଗୋଟେ case କରିଥିଲି ଯାହାବି, ତ ମୁଁ ସେଟା ଭାବିକି ମୁଁ କଣ ନା ସେ ସମନ ଟାକୁ ଫେରେଇଲି। So it is a notice ଯେ ସେତେ ତାର ମୁଁ ଏଟା ଗୋଟେ ଆପଣଙ୍କୁ କନଷ୍ଟ୍ରକ୍ଟିଭ ନୋଟିସ ର ଏକ୍ସାମ୍ପଲ ଦେଲି। ଆକ୍ଚୁଆଲ ନୋଟିସ ମାନେ ସପୋଜ ମୁଁ ମତେ ଗୋଟେ ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ଆସିଲା, ମୁଁ ଖୋଲିକି ପଢିକି ଦେଖିଲି ମାନେ if there is anything that is written in it which is relating to the transaction that is happening right now, it will be deemed that I have a notice thereof. Now notice can be of two types. One is actual notice, another is constructive notice. Actual or express notice is a notice that when a person actually knows a definite information, it must not be a vague information, ଗୋଟେ ଅଫୱାହ ନଥିବ। ମୁଁ ମୁଁ ଗୋଟେ ଏକ୍ସାମ୍ପଲ ଦଉଛି ଯେ ଗୋଟେ ମୁଁ ପ୍ରପର୍ଟି ଟେ କିଣିବାକୁ ଯାଉଛି, ପ୍ରପର୍ଟି ଉପରେ ପ୍ରପର୍ଟିରେ ଏବେ ମାନେ ସେଠି ଚାରିଆଡେ there is an afwa that there is a rumor that the property is haunted. ସେଠି କିଛି ଗୋଟେ definite information ନାହିଁ। This is not a scientific information or not a definite information କି ସେଠି ଭୂତ ରହୁଛନ୍ତି or ଭୂତ ବଙ୍ଗଲା ବୋଲି କହିକି rumor କରୁଛନ୍ତି। It will not be treated as a definite information କି ତାପରେ ପରେ something happens or କିଛି ତାର value ରେ କିଛି ଏପଟ ସେପଟ ହେଲା or contract ଟା fail କରିଗଲା, in that case you can't ମାନେ say କି ଆରେ ତ ସବୁବେଳେ କହୁଥିଲେ ସମସ୍ତେ that ସେଟା ଭୂତିଆ ବଙ୍ଗଲା, ତୁ ଜାଣିନୁ ସମସ୍ତେ ତ କହୁଥିଲେ ଭୂତିଆ ବଙ୍ଗଲା, ତୁ ତାପରେ ବି କାହିଁକି କିଣିଲୁ? You can't say that because it must be a definite information. ହଁ ସେ ଘର ସାମ୍ନାରେ ମରା ହେଇଛି ଗୋଟେ ନୋଟିସ that ଏଇଟା ଅକ୍ସନ ପାଇଁ ବ୍ୟାଙ୍କ ଆକ୍ୱାର କରିଛି, ଏବେ ଅକ୍ସନ ପାଇଁ ନୋଟିସ ପକେଇଛି। ଘର ଆଗରେ ଗୋଟେ ଆଫିକ୍ସ କରିବା ପାଇଁ ହୁଏ, ଅକ୍ସନ କଲା ବେଳକୁ ଜାଣିଥିବେ ଘର ଆଗରେ ଗୋଟେ ଆଫିକ୍ସ କରାଯାଏ। In that case the bank has put it in front of the house, ତମେ ସେଟାକୁ ଦେଖିଲ, this is a definite information. If you see that and you say ki no ମୋର notice ନଥିଲା, you can't say that because this is a definite information. Rumor, indefinite information, that is I'm not concerned with here. And then it must be relating to the same transaction. The second ingredient that is to be satisfied for an actual notice to happen is that it must relate to the same transaction. That means ମୁଁ ଯୋଉ ଘରଟା କିଣୁଛି ସେଇ ଘର ବିଷୟରେ କଥା ହବା, ସେଇ ଅଲଗା ଗୋଟେ ଘର ବିଷୟରେ କହିଲେ it will not be presumed that I have a notice over that. It must relate to the same transaction and the notice must be made to the actual party or the party who are actually parties thereof and made or given by the interested party. ସେଇ property ଉପରେ ଯୋଉ bank ମାରିଲା, bank ଯୋଉ ଗୋଟେ auction ର ଗୋଟେ notice ରେ ମାରିଲା, the bank is interested in that property, then they gave a notice and you have to have that notice because it is made by a party which is interested in that property. When random person comes and he makes any statement about that, you need not, because he's not interested also, and it will be deemed as if you do not have actual notice over it. Then coming to the second part of the notice, which is a trickier part, constructive notice. Even if you do not have actual notice or express notice, court sometimes will construe or deem that you have the notice there. The first example that I gave you, that court would summon kala registered post tray, it came, the postman came to the door, rang the bell, you opened it, you saw that code aschi se kala civil code ru aschi, oh se jo check bounce karthili, I think it must relate to that, it must be relating to that, and that's why I said ki 100 ଟଙ୍କା ନିଅ ଭାଇ ଯାଅ, ଦରକାର ନାହିଁ ମତେ ଦବା ରେଜିଷ୍ଟର୍ଡ ପୋଷ୍ଟ ସର୍ଭ କରିବା ଦରକାର ନାହିଁ, ତମେ ଯାଅ। ସିଏ ଲେଖିକି ପଳେଇବ ଡୋର ଲକ୍, ସିଏ ଲେଖିକି ପଳେଇବ party not received or something else, a party not received or refused to deliver. Then in that case it will be deemed as if you have the notice of the summons. Actually summon to dekhi nahi, kholi ki dekhile jante summon achi, but you, just because you thought that it must be of the court and you willfully avoided the same, it will be deemed as if you have the notice. So basically it is a notice which a reasonable person ought to know. Reasonable person jodi apna ଟିକେ reasonably hai ki you must have ଟିକେ slightest use of brain would have allowed you to be aware of that fact, then it will be deemed to be a constructive notice. Plum versus Fluid case, it has been dealt that an evidence in itself, the constructive notice will be deemed to be an evidence in itself, and it can't be disproved. If court says that yes, you have constructive notice over the fact because you refuse the delivery, that means it will be deemed that summons was served on you, duly served on you, because you had the notice, you had the opportunity, but you willfully avoided it. The same, then in that case it will be an evidence in itself and it can't be disputed. The act says that it is nothing but an willful abstention from an inquiry or search which he ought to have made. If a person abstains, that abstention must be willful from an inquiry or search that he ought to have made, then in that case, if he would have made such inquiry or search, he would have definitely known it. But he willfully abstained from it, willfully abstained from making such inquiry or search, then in that case, it will be deemed that he has constructive notice over the same. Second part is, if not for gross negligence, he would have known it as well. Dita outrightly dita प्रकार constructive notice. First is willful abstention ପାଇଁ ଜାଣିଥାନ୍ତା, or gross negligence ଯଦି ନ କରିଥାନ୍ତା, he would have definitely known. The example is very well narrated in a case called Lloyd Banks versus P.E. Gupta. The case is thus. The case is that a bank thila, ଗୋଟେ bank who a person went and said that I want a loan. Bank କଣ କଲା ନା ତାର ଜମି ଜାଗାର ଯେତିକ କବଲା ଫବଲା ସବୁ ରଖିଲା, ତାକୁ ଗୋଟେ ଲୋନ୍ ଦେଲା। ଲୋନ୍ ଦେଲା ପରେ ସେ କଣ କଲା ନା ସେ ଲୋନ୍ ଟା ନେଇଯାଇଛି। ଏବେ ଯୋଉ ପ୍ରପର୍ଟିର ସିକ୍ୟୁରିଟିଟା କଣ, ସେ ଯୋଉ ମର୍ଟଗେଜ ଯୋଉଟା ପକେଇଲା, ଯୋଉ ଜମିଟା ପକେଇଲା, ସେ ଲୋକ ପୁଣି ଯାଇକି ଆଉ ଥରେ ବ୍ୟାଙ୍କକୁ କହିଲା କି ମତେ ଟିକେ ସେଟା ଦେଖିବା ପାଇଁ, ମତେ ଟିକେ ସେଟା ଦେଖିବା ପାଇଁ ଦେଲ, ମୁଁ ଟିକେ ଦେଖିବି ତାକୁ, ସେ ଇଏଟାକୁ। the bank knowing that it is the only security, କି ମୁଁ ଯଦି ଏଟାକୁ ହଜେଇ ଦିବି କି କୁଆଡେ ଯିବ, ତାହେଲେ ମୋର ପଇସା ମିଳିବାର ବି ଚାନ୍ସ ନାହିଁ, ଷ୍ଟିଲ୍ ବ୍ୟାଙ୍କ କଣ କଲା ତାକୁ ଧରେ, ଆଣ୍ଡ ସିଏ କଣ କଲା ନା ସେଟାକୁ ନେଇକି ପଳେଇ, ସେ ଯୋଉ ପ୍ରପର୍ଟିର ଯୋଉ ଜମିର ଯୋଉ କାଗଜ ଗୁଡା ଥିଲା ତାକୁ ଧରିକି ପଳେଇଲା। In that case, it will be deemed as if the bank had the constructive notice over that. କି ସେ ଜାଣିଥିଲା, ସେ କହିବ କି ମୁଁ ତ ଜାଣିନଥିଲି ସେ ନେଇକି ପଳେଇବ, ନା, you knew that କି ଧରାଯିବ କି constructive notice ଅଛି, କାହିଁକି ନା you did not exercise your brain at all. Your brain froze for certain time. Gross negligent act ଏଠି କରିଛ, ଯୋଉଟା ଜାଣିଛ ଯେତେବେଳେ ମୋର only security that is, and you still gave it, it will be presumed that ki you have constructive notice over it. Explanation or proviso गुड़ा ସେମାନେ explanation गुड़ा actually ଆଉ ତିନିଟା ଜିନିଷ କହୁଛନ୍ତି which will be called constructive notice. ଦିଟା ତ ଆମେ ଜାଣିଲେ, ଗୋଟେ willful abstention ହେଲେ ହବ, ଆଉ ଗୋଟେ gross negligence ଯଦି କଲା ତାହେଲେ ବି ହବ. Third part is that when registration will be a notice. registration ଟା କେତେବେଳେ ଗୋଟେ notice ହବ ସେଇଟା କହିଲା that a registration will be a notice ଯଦି ଗୋଟେ କିଛି ଜିନିଷ registered ହେଇଯାଉଛି, it will be deemed as if the person concerned has notice of that, because the conditions that have to be fulfilled in order to become for a registration to be a notice is that the document which has been registered, that must be required by law to be compulsorily registered. First ingredient for registration to become a notice is that it must be compulsory to be registered. That document must be compulsory to be registered under law. And second ingredient is that all formalities of registration act, those formalities must have been completed. Third is that this registration will affect as a notice to the people who are coming to the picture after the registration, not to the people who are retrospective to the registration. Retrospective to the registration, they will not be bound by such registration and they will not be taken as if they have a notice of such registration. But if people who are coming after the registration, they will be bound as if they have the notice of such registration. That is the third part. That registration will be a notice when, if it is the document is compulsorily registered and all formalities are fulfilled that are required by the registration act. Fourth thing that is will be deemed to be a constructive notice, that actual possession. Actual possession will be deemed as a notice of title. That if I am staying in my house, ମୁଁ ଘରେ ରହୁଛି, ଗୋଟେ ଲୋକ ଆସିଲା, ଗୋଟେ ଲୋକ ବାହାରେ ଠିଆ ହେଇ କହିଲା କି ଏଇ ଘରଟା ମୋର. You must have seen that movie Hera Fairy, in which Akshay Kumar was standing in front of a bungalow and he was trying to sell it, and there were people who were being fooled by that. So if that happens in a real situation, real life situation, when someone is standing in front of my house and selling it, and the other person who is being sold the property, he sees that I'm staying here, he's staying here, he's seeing that, तो देखुची कि ମୁଁ ଏଠି ରହୁଛି, but still ସେ ଭାବିଲା କି ନା ଇଏ ତ ବିକୁଛି ଆଉ, ବିକୁଛି ମାନେ ମୁଁ ତାଠୁ କିଣିଦେବି ଆଉ. In that case, though ସେ କହିବ ପରେ ଆସିକି ଯଦି କହିବ that ମୁଁ ଜାଣିନଥିଲି କି ସେ ରହୁଥିଲା ନା, ମୁଁ କେମିତି ଜାଣିବି ତାର ଟାଇଟଲ କିଛି ନଥିଲା କି ତାର କିଛି ବି ତା ଉପରେ କ୍ଲେମ ନଥିଲା. You can't plead that. If I am in actual possession, it can't be the fact that maybe it is not true ki I am the owner of the property, but I have some interest. मते quarter दिया है or rent रे रोची or anything, I must have some interest. That is the reason I'm in actual possession thereof. तापरे भी से कहूची that किसी सेमती नहीं पूरा negate करूची, that can't be allowed. An actual possession will be treated as if there is a notice to the title that has been given to the party concerned. Now the fifth part is that notice to agent will be deemed as if it is a notice to the principal. That means that I'm a principal and I have appointed an agent, and if the agent has received a notice, then it will be deemed as if the principal has received a notice as well. But for that also some conditions have to be satisfied, that it must be in the same capacity. That agent ଯେତେବେଳେ ଜାଣିଲା, it must be that he was acting as an agent and then he knew it. ଏମିତି ନାହିଁ କି ଯେ ସିଏ ତାର personal capacity ରେ ଥିଲା ସେତେବେଳେ ଜାଣିଲା, that is not to be counted as a notice. Must be in the same capacity, must relate to the same transaction or business, and must happen during the same tenure of agency. That means जो period ରେ ମୁଁ ତାକୁ agent ଭଳିଆ ରଖିଛି ସେଇ period ରେ ହବା ଦରକାର, जो transaction or business I am concerned with ସେଇ transaction की ସେଇ business ସହିତ concern ହବା ଦରକାର, ଆଉ same capacity ରେ known ହବା ଦରକାର. Then it will be deemed as if the notice to the agent will be the notice to the principal. Exception here is that agent मोर जाएगी का सହିତ मिसिकी ଗୋଟେ ପାର୍ଟି ସହିତ ଯେ କି ଏଇଥିରେ ଇଣ୍ଟରେଷ୍ଟେଡ ଅଛି, ସେ କଣ କଲା ନା ମିଛି ଗୋଟେ fraudulently ଲୁଚେଇ ଦେଲା ଗୋଟେ ଜିନିଷ କହିଲା. ସବୁ ଏକ୍ସାମ୍ପଲ ପୁରା ଦଉଛି ଯେ ମୁଁ B is my agent, C is interested to sell this property to me, but B କଣ କଲା ନା ଜାଣିଥିଲା ଯେ C ର ସେ property ଟାରେ କଣ ଗୋଟେ problem ଅଛି, some problem कि तार केस चलची और इसी क्लियर नहीं, whatever is it, से जानी थिला. But being my agent also, से कहला ना connivance रे act करिकी, he acted in connivance with the a person who is concerned, who is trying to sell it to me, and से कहला ना मते लुचेला, ताबु कहिथिला but से कहला. In that case, I will not be having a notice of that fact against that person. Right? It is clear to you. Now the section 4 we already discussed. What is it dealing with? That it is nothing but a continuation to the Contract Act, and it supplements the Registration Act. And coming to section 5, which is defining transfer of property, it says that the transfer of property, when I say that transfer of property, it means an act by which a living person, if he conveys his property, and so 5 ingredients you have to remember in order to know what is a transfer of property. That act of conveying a property, it must be either in present or in future. I can say that right now I'm transferring, or on the happening of certain event, or at a future time, or at a future date I'll deliver it to you. That is also allowed, but it must be done by a living person, and it must be transferred to one or more living person. It can't be transferred to a dead person. It can't be transferred by a dead person. It must be transferred by a living person. It must be transferred to one or more living person, or himself and another more living person. And how can I say? You must be saying that can it be transferred to himself? Can I transfer? I Rajat, can I transfer the property that I have to Rajat himself? No, he can't. But himself and others, that I am the only sole owner thereof, then I'm transferring it to Rajat and co. In that case, it is allowed. Or Rajat in some other capacity, Rajat as a principal of a college, or Rajat as an agent of a company, and some other person, that is also allowed. And when I say living person, that includes companies. So this is basically transfer of property. This completes our discussion on introduction to transfer of property. Next class, that is going to be held tomorrow, we'll discuss what may be transferred, which is very important. We'll also discuss the persons who are competent to transfer, how the operation of transfer takes place, and which are the restrictions repugnant to the interest created. All of that we'll probably discuss transfer of benefit of unborn person as well. We'll try to go to that section 13 and section 14, which is very important. If not, maybe we'll discuss them day after. But for now, let's conclude our discussion on the introduction to transfer of property. If anyone has any doubt, let's just raise our hands and I'll one by one unmute yourself and ask. So I'll presume that everyone is clear with all the discussion that happened today. Okay. Yeah. Since nobody is asking a doubt, I'll presume the same. In case you have a doubt, you can definitely drop a message in the group and we'll take it from there. Okay. Thank you, everyone. Have a great evening.